Matter of Fowler versus Akzo, Nobel Chemicals, and Union Carbide Corporation. May we please have appearances of counsel?
Good afternoon, Your Honor. Amber Long from Levy Koningsberg.
Good afternoon, Your Honors. Jared Placitella from Cohen, Placitella and Roth. Today on behalf of Amicus Curiae, New Jersey Association for Justice.
And good morning, Your Honors. Michael Scodro from Mayor Brown here on behalf of the respondent Union Carbide.
Welcome, counsel. Ms. Long, please go ahead.
May I please reserve 2 minutes at the end for rebuttal?
Yes.
Thank you. May it please the court. The holding of the appellate division must be reversed because it wrongfully upended the long-standing non-delegable duty of a manufacturer to provide an adequate warning of the hazards of its product to the foreseeable users of the product. The panel did this by finding that this duty may now be discharged by relying on third parties to relay warnings. Fundamental to our strict products liability jurisprudence are 3 long-standing rules. 1, that a product manufacturer has a duty to the reasonably foreseeable users of its product. 2, that the manufacturer may not delegate this duty. And 3, that specifically in the employment context, the manufacturer has the duty not only to warn the user of the product, but also their employer. That a manufacturer has a duty to warn the foreseeable users of its product has been the rule in this jurisdiction for decades and was recently reiterated by this court in the Whalen matter in 2020, when the court stated that a manufacturer's duty to a foreseeable user of its products has long been recognized.
Ms. Long, if I can ask you, the appellate division agrees with you that the manufacturer may not delegate its duty to warn and has a separate concurrent duty to warn both the employee and the employer. And that's your 1 and 2 points, 1 and 2. And your third point regarding the duty to warn the user, the appellate division is setting up essentially not setting up, but stating that there are circumstances that ultimately may or may not prove that it's reasonable to warn in particular ways. And what I'm wondering, and I'm raising this in part because you made similar points in your brief. Why is the appellate division's rule, which relies on a determination of reasonableness that is very fact specific, in any way a departure from our product liability law as it's been historically developed?
Sure, there are several reasons, Your Honor, why it is the departure. The reasonableness rule that the appellate division adopted is a departure from our jurisprudence. As we discussed in our papers, the focus in strict products liability is not on the defendant's conduct, rather the safety of the product. This has been reiterated by this court several times in the Whalen matter, in the Kaufman matter, and the court has held that under strict liability, the manufacturer of a defective product that causes injury is held liable even if the manufacturer acted reasonably. And that was the ruling in O'Brien, which was decided in 1983 by this court. And in that case, the court wrote, under strict liability, a manufacturer that produces defective products is liable even if those products are carefully produced.
Right.
Further,
right. But when we're talking about a warning case, design defect is obviously a whole category that, as I understand, is really not our issue here. We're talking about a failure to warn case. And
sure.
And of course, you would agree that courts can take into account the particular circumstances that the situation presents. You know, what the nature of the danger is, what warnings are feasible, and what the manufacturer did to warn, and judge that under a standard of reasonableness.
I don't agree with that under strict liability, Your Honor. I think that the case law is clear that even if the manufacturer acted reasonably in strict liability, if their product contained an inadequate warning and thereby injured someone, they are responsible. And that is a difference between negligence and strict liability that I think in some ways the appellate division overlooked here when they formed a reasonableness rule. And there is a connection between design defect cases and failure to warn cases. In Bashada, this court wrote that there are strong conceptual similarities between warning and safety device cases. And that's why we have relied on and pointed the court to the safety device cases such as Bexica in our papers. I think Bexica is very instructive to the court here because in that case, the Supreme Court rejected the appellate division's reliance on the restatement. It said that if the restatement would allow a manufacturer to rely on the purchaser to install a safety device, then the restatement should be rejected. That same reasoning applies here. You could take the holding from Bexica and substitute in adequate warning for the phrase safety device, and the holding would be equally applicable to the circumstances here.
But counsel, we're talking about the feasibility of safety devices in a design defect claim, and our jurisprudence, while the concepts have a lot of common ground, the warning law has developed as warning law. And obviously in asbestos cases, we're not under the PLA. So that I'm not suggesting in any way the PLA section applies, but the warning law does take into account the nature of the various relationships in the case and the ability to provide a warning that in terms of how to reach the ultimate end user. And sometimes, as the appellate division seems to be suggesting here, we want manufacturers to think about reaching the ultimate user through the employer as well as directly. In this case, as I understand it, there were two different paths to convey the information to the end user, and one was direct on the packages and the other was through the employer.
Well, and I think,
no, please go ahead.
I think what's critical about what you said there, Your Honor, is as well as. In the employment context, there are two duties to warn. If the information conveyed to the employer is allowed to be considered in assessing the adequacy of the warning to the employee, then what the court intended to be an additional duty on the manufacturer has now been allowed to completely supplant or replace the duty to warn the employee. And the problem,
I respectfully, I don't read the appellate division as saying anything so extreme. I think as I read what they were doing, look at MSDS, for example, that's something that historically has been provided to employers for distribution and posting and so forth in an employment setting, that's one area in which an effective warning can be delivered, and we want to incentivize manufacturers to provide warnings any way that they can, that they can deliver an MSDS to the employer and therefore have it available to the employees, as well as what it seems to have occurred here, which is warnings on the package.
Sure.
So what is so different about this appellate division decision from the prior law?
Well, what's different about it, Your Honor, is that in this instance, the jury found that the warnings on the product are inadequate. I don't think that Union Carbide or the Amici have pointed to one case where the warnings on the product were found to be inadequate, but yet a manufacturer was still allowed to escape responsibility because they acted, quote unquote, responsibly or reasonably. That is just not part of strict liability, where it may be part of negligence. And yes, we do want manufacturers to warn through both methods of communication, directly to the employee and to the employer, and that's what Kaufman and Thier held.
Right.
But for example, the MSDSs that you raised, Union Carbide made a choice not to send those to Mr. Edenfield and his coworkers. Those MSDS sheets could have been included in the pallets of asbestos that Union Carbide shipped to Mr. Edenfield's employers. Instead, Union Carbide decided not to send those to the product users, but rather to send them only to the employer. By doing this, Union Carbide has now taken the choice of whether to work with this hazardous product out of Mr. Edenfield's hands by not providing him with all the information he needs, and instead has made it so the employer now has the choice of what to pass on to Mr. Edenfield or not. And the court has said that we do not leave product safety to the haphazard conduct of the purchaser. The court has acknowledged that employers will subject their employees to dangerous conditions, including exposure to asbestos. And this is part of what has led the courts to reject the idea of a sophisticated user defense under New Jersey law.
But
And
all
I
that
think-
goes, as I understand what the appellate division wants to do, is it wants to present all of that, all of those facts, and have the jury make a determination, ultimately properly charged, as to the adequacy of the warnings in each case, or in potentially 4 or 5 different routes. And yet the issue with this charge that the trial court gave is that the jury was told, and there was even a jury question about it, the jury was told what happened with the warnings provided to the employer cannot be considered. As I understand what the language was, the duty to put an adequate warning on the product may not be discharged by warnings and information to the employer.
Correct. And that was a correct statement of the law, because the duty to warn the employee cannot be delegated. And that is relying on the employer to pass on information is the definition of delegating. In Hughes, the appellate division said that the manufacturer could not rely, using that word specifically, upon plaintiffs' employers to issue warnings to employees because the duty to warn is non-delegable.
So the court, tell me if I'm mistaken, because I'm trying to, this is a very complicated case. But on the verdict sheet 3A, when the jury asked for an explanation, the court was limiting itself to the warnings on the bags. He wasn't talking about 3B. 3B dealt with the employer. So he was basically saying, that's all you look at with respect to the warnings on the bags. Were they adequate or were they inadequate? Am I correct?
That's correct, Your Honor. And in this case, the only evidence of direct communications with the product users were the warnings on the bags. I'm not saying that there's...
Yeah. The second piece, I'm trying to get a hold of this, is so the one where he says, no, has plaintiffs proven by a preponderance of the credible evidence the defendant Union Carbide failed to take reasonable steps to ensure that its warnings reached Mr. Edenfield. That's a failure of proof. We don't know whether or not they actually informed the Edenfield. All we know is just the plaintiff didn't prove that piece of it. It doesn't show that Union Carbide affirmatively told him about the dangers. Am I correct?
That's correct, Your Honor. In fact, Union
Isn't it always
Carbide did
plaintiff's
not...
burden of proof? Counsel, isn't it always
I'm
plaintiff's
sorry,
burden
Your
of
Honor?
proof? Isn't it always
It
plaintiff's
is the...
burden of proof? It's not that the
That's
defendant
correct,
has to
Your Honor.
prove what they did or did not do. The burden lies with the plaintiff first to prove that something was amiss, it was negligence, it was failure to warn, whatever. It doesn't shift at any point, as I understand it.
Well, that's correct. Well, unless we get to the heating presumption, then it would shift.
But
But
that
He-
wasn't what that was about.
The heating presumption's not in the case.
in
He
this
got the benefit of
instance,
the heating presumption.
Yeah, the only relevance of what my question was, we know affirmatively what the jury found. They found that the warning was inadequate.
correct.
Okay, we don't know whether or not the manufacturer did anything to disabuse the employee of the inadequacy of the warnings.
There was no proof in this case that Mr. Enfield received any of the information that Union Carbide purportedly gave to the employer.
Right, but in terms of what
Purportedly
proofs
to
there,
pass on.
what proofs there were, the gentleman is deceased. Really, all the
Correct.
evidence came through his coworker.
That's right,
And,
Mr. Dover.
And so in terms of anyone testifying that him testifying, unfortunately, he had died before trial. He didn't testify whether he did or didn't get warnings, but there was quite a bit of evidence. Tell me if I'm wrong about what the manufacturer sent to the employer and what they requested be disseminated to the employees. Am I correct about that?
There was quite a bit of conflicting evidence on that, Your Honor.
Okay, but
back and
evidence,
forth.
and I know, I'm sure you did an admirable job of presenting, you know, the other side of that, but there was evidence from which a reasonable jury could make a determination that the manufacturer sent detailed information to the employer with the request that that be passed along to the employee, right?
They could have been, there is a version of the facts from
I'm
which
just
they
saying
could
reasonable,
infer
that a
that.
reasonable
Yes, Your
jury
Honor.
could infer. I'm not asking you to
Correct.
concede what evidence was stronger, but that the evidence is there. And then you have the jury finding what it did on that second question, right? Which is the plaintiff did not meet her burden of proof with respect to that issue.
Correct. If
Okay.
there had been an adequate warning on the product, then we would have lost, because they also took the second step
Yeah,
that's required by Kaufman to
right,
make sure that to also warn the employer.
right. So
But
that
they
the
never-
jury, I'm sorry, the jury finding is, and I understand Justice Albin is saying we don't know for sure because we don't have the plaintiff saying this, or the plaintiff's
I think
decedent
that's
saying it.
correct.
But the jury finding is that aspect of the case was not proven by the plaintiff.
Right. To the extent the plaintiff did not prove that they did not take reasonable steps to get
Yeah.
the information to the
Okay.
employer.
But that, yeah. So let me ask you a question about proximate cause. I'm gonna help me out. If the jury, we know they found an inadequate warning, but if the jury determined that the employer actually told the employee about the dangers, wouldn't that have interfered with the proximate cause? Then the jury might not have found that the inadequate warnings were the proximate cause of the injuries. Am I mistaken in thinking?
I think you're right, Justice, that if there was evidence that Mr. Edenfield was warned and ignored those warnings, that would rebut the heating presumption and go to causation.
But we don't
So
have, that's
this
not in
evidence
this, that's
does
not
come
in,
in.
that's not in this case. And the jury was never asked specifically, did he receive those warnings, right? That wouldn't be an appropriate thing to ask a jury in this kind of case. The jury found that the plaintiff did not prove that the manufacturer didn't take reasonable steps in order to see that I'm paraphrasing, see that the employee got the warnings. That's what the jury was asked to determine, and that's what it did determine.
I disagree with the exact wording of that, Your Honor. I think that the jury
I wasn't
found-
I wasn't reading from,
Sure.
I was only paraphrasing, but the jury,
What-
I'm sorry, go ahead, please.
What I think the important distinction there is that the jury found in answering question 3B that the manufacturer took adequate steps to warn the employer.
Okay. Now, you
The-
mentioned earlier that reasonableness doesn't belong in the case. Are you
Correct.
saying that asking the jury if they took reasonable steps, as this trial court did, which certainly you didn't object to, was not an appropriate way to put that before the jury?
For that question, I think it was appropriate because that's the specific language from Kaufman.
Right.
But
So
then when
going
you
back,
look
so
at-
going back to the beginning of your presentation, reasonableness is the test as to that aspect, is it not? And if it's not,
Only as to as to taking those steps to get the warning to the employer. The test for the adequacy of the product warning is not a negligence or a reasonableness standard.
understood,
It is the
but when-
product safe.
when you started out, you said this is all wrong, reasonableness doesn't belong, that's negligence, that's not in here. And the reason I was confused about it was my first question is, reasonableness as to steps that a manufacturer takes to reach an end user in the industrial setting and a workplace setting has always been part of our law.
Again, I
Right?
think Kaufman was talking about reasonableness in the steps to reach the employer.
Right.
The question about a warning on the
No, I'm not
adequacy
talking
of a
about the
product
content.
warning.
I'm sorry, I wasn't talking about the content of the warnings. That's not a reasonableness test. But when you said that this appellate division decision is really wrong because it uses reasonableness and we're getting strict liability all mixed up with negligence, and this is really contrary to our law. The reason I say this is because this is that aspect of a failure to warn inquiry in a workplace case has always been a reasonableness test, hasn't it?
I don't agree. No, Your Honor. I think that
Well, then
you
why?
get to the reasonableness step after the first question. And the first
Understood.
question has to be, was there an adequate warning? And I
Completely.
don't think you really get to the reasonableness unless there's an adequate warning, because is there an adequate warning? And then secondly, did the manufacturer take reasonable steps to make sure that adequate warning got to the employer? But you have to have that first step, which is not a reasonableness inquiry.
But here, what the trial court did was essentially say that the reasonableness, that the adequacy of the warning had to exclude everything that was done by the manufacturer. So
everything that wasn't communicated that wasn't directed from the manufacturer to the end user, yes, that should be excluded in addressing or assessing the adequacy of the warning on the product to the end user. You cannot look at communication outside of that.
Tell me that the trial court basically followed Kaufman, and Kaufman said, you got to give warnings to the employee and you got to give employees to the employer. And they said those are concurrent responsibilities because Kaufman understood that certain employers are not going to adequately tell the employees. And that's the reason why there's a non-delegable duty on the part of the manufacturer to speak directly to the employee.
That's exactly right. That's what the court found.
But Kaufman also said that the manufacturer may sometimes, not always, rely on supervisors and managers to become apprised of safety hazards and retransmit those warnings orally to workers rather than having the workers individually read product warnings, and also noted that's a typical method by which information is disseminated in the modern workplace. That's a very old case, obviously. That's why
Isn't that part and parcel of the reason the manufacturer warns employers so that they will in turn warn their employees? Isn't that part and parcel of the reason, the rationale for having the manufacturer warn employers?
It is, but again, it needs to be an additional duty because, as Justice Salvin said, we can't count on the employer to pass those warnings on. In fact, the law says that it's that a manufacturer, the knowledge that an employer won't pass those warnings on is imputed to the manufacturer. And so that's why it needs to be an additional duty. And yes, the reason for the additional duty is so that the employer will allow the employee to act more safely. And so that if they, for some reason, don't get the warning on the product, there's other ways for the warning to get to them. But Kaufman presumes it starts with the adequate warning to the employee, to the product user. The addition,
they work hand in hand.
Exactly, but they can't. But the interpretation that the appellate division put on it below,
In this case,
doesn't allow them to work hand. It would allow no warning on the product, or as in this case, an inadequate warning on the product, and then additional information to the employer to somehow satisfy the adequacy of the warning on the product. And that's what we're saying cannot be allowed.
That's your reading of the opinion, or your analysis of the opinion in this case?
Of the appellate division below, yes.
Right.
I mean,
Okay.
they said outright that essentially adequacy of the product warning would only be one factor in a reasonableness test. So they've taken what should be the key inquiry, is there an adequate warning on the product? and made it just a factor in a reasonableness inquiry, which again strips away strict liability and essentially makes it a negligence inquiry.
And
which
one
is
of the reasons Kaufman required this two-pronged approach, and I'm quoting, unfortunately, there are examples of employers who fail to take reasonable measures to ensure the safety and health of their employees in the face of warnings. Some don't. Many responsible ones do it, but the court was focusing on direct communication with the employee, and then hopefully this second prong with the employers, an extra level of coverage and protection. Am I correct about Kaufman?
Correct. And that is the solution that the court came up with in Kaufman to the issue of workplace warnings and how best to protect worker safety. And the rule that the appellate division adopted violates our public policy in several ways because, for instance, risk spreading is a major goal of our strict products liability. In Bishada, the court said that manufacturers are best placed to spread the risks. They can factor the cost of the injuries into the price of the product, insure against it, and pass that on. And that is far more desirable under our law than the innocent victim, the worker, suffering the risks and the costs on their own.
But that, counsel, that's a very general statement. If that were the overriding principle in every product liability case, there would be no incentive for the employers to do the right thing and warn, because the adequate warnings and the measures they may take may or may not, but if they do take to get the employer the information they need, would do them no good, because the overriding issue would be we're just going to spread the risk to manufacturers. I mean, I think that's a general principle that guided the development of our product liability law, particularly in asbestos cases early on, but that doesn't answer the question as to how best to approach a particular factual scenario. Would you agree with that?
I think it's important to consider here, Your Honor, because the result of the appellate division rule is that Mr. Edenfield and other workers like him will be the ones to bear the risks, because the manufacturer will be able to evade liability by saying it reasonably relied on the employer. The employer is not subject to suit and tort. And so there is no remedy in the tort system left for the innocent injured workers who never received adequate warnings of the products that they were working on.
But you're assuming they're not taking,
important here.
You're assuming they're not taking reasonable steps. I mean, I don't think there's anything that in the appellate division's decision that obviates the need or even lightens the burden on employers, on manufacturers to take those reasonable steps as your jury instructions reflected, which is the part of the test here.
But even if they take those reasonable steps, Your Honor, there's no guarantee that the employer will pass those warnings on. And so by putting this employer in the middle and subjecting the communication of warnings to their haphazard conduct, we are creating situations where innocent victims are going to be the ones to bear the responsibility because the manufacturer acted reasonably in relying on the employer. The employer, maybe they acted badly by not passing those warnings on, but there's no way to hold them responsible in tort. So the workers are the ones who end up left holding the bag, so to speak.
What prong two doesn't do, and it's the reason why it doesn't necessarily cover one. Prong two is that the manufacturer does reasonably advise the employer. It's not reasonably advise the employer and ensure that the employer told the employee. That's not the correct. That is not part of our jurisprudence. They get away with this.
Correct.
And that's the reason why the first part, the communication with the employee, has been always critical to our jurisprudence.
Absolutely correct, Your Honor.
But that's not abandoned by the appellate division at all. I mean, the appellate division talks about that. And let me ask you this: if you put an MSDS in a pallet, is there any guarantee that the employees who are busy and under pressure and in the workplace are going to stop and read an MSDS?
There is no guarantee, Your Honor, but that doesn't. But putting it in there is no burden on the manufacturer. As our courts have repeatedly said, adequate warnings are minimal, if any, burden on the manufacturer. And if including that increases the likelihood, if it at all increases the likelihood that Mr. Edenfield or his coworkers would see it and be safer, then that's what the law requires.
What just out of curiosity, was putting an MSDS in a pallet something that happened in these asbestos situations during this time period?
I believe there are manufacturers who include MSDS sheets directly with the products as opposed
that's
to
delivered to the
sending them
employer.
separately.
That's delivered to the employer.
Well,
right?
the product is delivered to the employer as
So
well.
the
but
MSDS
they put it
I'm sorry.
with
Go
the
ahead.
product.
Yeah, okay, but it ultimately goes to the employer, and the employer could be unpacking these things and throwing the MSDS in the trash, presumably.
They could, Your
right?
Honor. It's possible. And
Were
because
there
we can't
inadequate
rely on employers not to do that is why the product should have an adequate warning on it itself.
In this case, were there inadequate warnings on the bags themselves?
There were, Your Honor. There were 2 warnings that Union Carbide placed on the product. The jury found the first warning that it put on in 1969, Union Carbide itself described as the most innocuous warning that it could devise. In 1972, it put the OSHA minimal required warning on the product, but we also presented evidence of internal documents from Union Carbide showing that they considered other warnings better warnings than the ones they put on there. They specifically said internally, the OSHA warning is inadequate. We could put another warning on, and then they didn't. And this was the evidence that led the jury to find that those warnings on the product were inadequate.
The reason why I'm asking this question, this isn't a question of leaving a pamphlet on a pallet. Union Carbide failed to put warnings on the bags that were being opened up by the workers.
That's correct. And they put warning, and the inadequate warnings they put on there could lull the employees, the product users, into thinking that's all the information. Certainly there was nothing on the bags that would have alerted Mr. Edenfield and his coworkers that their employers had any additional information and that they should seek that information from them. So what appeared to be a whole complete warning was on the bag, but that warning was inadequate and didn't contain the information that the employees needed to know how to work safely with the product or to decide whether they wanted to work with it at all. And so by providing that inadequate warning and then allowing them to delegate their duty to provide all of the necessary safety information to the employer, leaving that up to the employer's choice, they have put the employees and the product users in a position to be injured and to not have that meaningful choice about how to work with the product.
Can I ask you 2 narrow questions? And they're very narrow.
Yes,
My understanding is that the jury concluded as to question 3A that the warnings on the bags were inadequate, period.
correct.
Is it your contention, I think it is your contention, that essentially the answer to 3B is then irrelevant, superfluous?
Yes, yes.
But the judge did not in the jury verdict sheet say if you answer yes to question 3A, you don't need to go to 3B, go directly to the next one, correct?
Correct.
Now,
I'm
so
sorry, go ahead.
hold on, I just have a couple of questions and I didn't want to interrupt the dialogue that was going on here. And I assume that your contention is no matter what efforts the manufacturer here gave, whatever efforts they engaged in to get additional information, because apparently there was additional information that was sent to the employer and you don't dispute that. Whatever efforts they made to get the information to the employer and have it passed along to the employee is essentially irrelevant because it was not delivered directly to the employee on the bag. Once you get to the warning on the bag being inadequate, that's the end of the story.
That's correct, Your Honor. And just one caveat, that is fact specific. If there had been any other evidence of Union Carbide trying to directly, as in
Here,
sending the
let me stop.
MSDS.
I didn't want to
but-
get a whole recitation. I just want to
But
understand.
yes, I agree with you.
There
Your
were
Honor, is
other
the short
pamphlets.
answer.
There were other pamphlets, there were other letters, there were other things sent to the employer with instructions to provide it to the employee. Your contention is that doesn't matter at that point.
That's correct. If
And my
the
last-
warning, correct, Your Honor.
My last question. I may be wrong, but my recollection of the record was that this employee, the decedent, the plaintiff's decedent, did not ever handle the bags, that the asbestos was in some kind of a vat or a bin or whatever. It was poured in by others, and he extracted it from that, put it in his container, and transported it to wherever he was applying, that he never actually handled the bags. Is that right or is that wrong?
That is wrong, Your Honor. In that, again, we didn't have Mr. Edenfield's testimony,
I
but
know.
there's certainly, based on Mr. Dover's testimony, the batchers, which is what Mr. Edenfield was, would go to the warehouse and get the bags of asbestos, take them to the batching room or the mill room, open them, weigh them,
plaintiff-
pour them.
So because my recollection made it's a voluminous record, that he actually handled the bags.
Yes, Your Honor. And I would state that even if he didn't personally handle them, which I think there
If
was
the
certainly
evidence is he handled them, it doesn't matter.
correct. But even if he didn't, he was in the same 20 by 20 foot room with other people handling them. And the court has talked about that, and indeed in the quote that Justice Patterson quoted from Kaufman about relying on people to pass on warnings was a citing to the Farabee case. And in the Farabee case, what the court was discussing is when there are adequate warnings on the product, we can assume that coworkers or employers may orally transmit those warnings to the injured worker. So even if the injured worker didn't read warnings himself, that doesn't defeat the plaintiff's causation proofs. And so that was what the Kaufman court was quoting when it talked about relying on orally transmitted warnings. So even if it was if there had been an adequate warning on the product, the heating presumption would apply, and we could presume that Mr. Edenfield would have followed it, whether he saw it or not. But in this case, there is evidence that Mr. Edenfield was actually the one opening the 10 or 40-pound bags of union carbide asbestos, weighing out amounts from them for then other people to use in other parts of the plant. So he was the one. There's certainly, the jury could infer that he was the one handling the bags.
Did he handle pallets?
The proofs were that because he worked with the smaller bags, so they said, what Mr. Dover said was the pallets would be picked up by forklift and moved.
Right.
But
And
those pallets were like he said the smaller bags, the ones they could carry, the 10 and 40-pound bags, they would just grab bags and carry them in.
Yeah, that's
But
what I
those would
thought.
come out of the
Yeah.
pallets. But the pallets themselves with the big bags were moved by forklift. But there's certainly, he was in the warehouse going to get the bags. So he would have, and we had evidence from Union Carbide that they shipped the asbestos in shrink wrapped pallets. So there was evidence that he would have been in contact with those pallets going into the warehouse and getting the bags from there.
Were there MSDSs posted in the plant?
There was no, Mr. Dover was asked if I don't know if he was asked specifically if he saw the MSDSs. He was asked if he saw anything posted, and I think he said he did not.
And did you have any evidence from the employer as to what their practices were with regard to MSDSs?
No, we had some evidence that they did do air sampling. That was in documents showing that air sampling for asbestos was done. There was evidence from Mr. Dover that when he requested a respirator, the employer provided one. And he also indicated that they provided ventilation, but he didn't recall seeing any posters or things of that nature on the walls.
How about clothing? What did they do with respect to his clothing? Did they give him?
Sure.
Go ahead.
Mr. Dover testified that they were given protective clothing or something to wear over their street clothes. So they would put it on when they got there, take it off before they left. So I had begun to discuss the policy considerations. In addition to risk spreading, the rule the panel has adopted will decrease product safety, which is another goal of our products liability. In Whalen, this court recently said that the risk inherent in a product containing asbestos components can be reduced to the greatest extent possible without hindering its utility with attachment of the proper warnings. And again, I think it's important to remember that attaching a warning to a product imposes no hardship on a manufacturer. It is the easiest thing in the world for them to do to make a product safer. Finally,
I like that first word. That was taking us to where I was hoping you would go, because I want to give you time to discuss medical causation. Go ahead.
Excellent. I think I can actually turn to that, Your Honor. There is all of this is in our papers and the papers to the appellate division. So I don't want to set us back any further, and I'll turn to the second issue of the trial court's jury instruction on medical proximate causation. The instruction given by the trial court was consistent with the model jury instructions, the practice in all mesothelioma trials in New Jersey, the scientific proofs presented at trial, as well as the explicit dictates of at least one prior appellate division panel. It was entirely proper and certainly not error.
Let me just ask you, just as a general matter, are you saying the Schultes charge is never been given in New Jersey in a mesothelioma case? I find that to be, because
as far as I'm aware, Your Honor, I have no, Union Carbide has not pointed to any instance, and in my experience, they have not, it has not been given. And I know that the MCL asbestos judge here, she said in the charge conference that she has never given the Schultes language in a mesothelioma trial.
is there a published appellate case that provides an exception from the Schultes charge for mesothelioma?
Well, I don't think there's any published case that talks about Schultes as a jury charge, Your Honor.
No, but Schultes is essentially defining what the proximate cause determination is for workplace exposure. Would you agree with me?
It does provide a framework for the courts to analyze whether an exposure rises to the level that it should be allowed to go to the jury, or whether a jury could reasonably find. Right. That is the standard. Right. It has been applied by courts in mesothelioma cases, but when it has been done so, it has been done with the recognition of the nature of mesothelioma and right. the ease with which it can be contracted. The correct court noted that if there's evidence that one or a de minimis number of fibers can cause mesothelioma, the jury may conclude that the fibers were a substantial factor in causing plaintiff's injury.
Let me ask you a very simple question. Does Schultes apply? This is why, and if I'm looking a little perplexed, I just found this entire thing to be rather peculiar. Does Schultes apply to asbestos mesothelioma cases in New Jersey? And I say Schultes, obviously this court accepted it.
As modified by Curac, Your Honor. It applies, but as modified by Curac.
We mentioned it in Whelan. And so what I'm trying to understand as I'm looking over the cases and reading the briefs is whether or not Schultes is even current with current science. And the reason why I'm saying that, I don't have the language of Schultes before me right now, but it deals with exposure based on frequency and proximity. And then you're saying, and there's science behind this, that even a small amount of exposure can result in mesothelioma. Now, clearly the substantial factor test, which is what was given in this case, is going to cover that, even a small exposure. But even though we've used it in Whelan, I'm trying to understand whether or not Schultes is an appropriate standard, given what we know about mesothelioma and how it's contracted today. Why don't you just explain that, if you can?
It is a very awkward standard for mesothelioma because of what you've articulated, Your Honor. And I think that's why the court had to modify it in Kurak, because and there were some unpublished.
Has Schultes been modified by our courts or reversed? Has Schultes been disapproved of by our courts or modified or reversed in any way?
I think it has been modified.
When
by
I was looking at the transcript,
Honor.
did you have experts testifying as to the signs, the causation has changed? Because I didn't see that.
Well, Your Honor, when we say it's
Did I
changed,
miss it?
Schultes was
No,
decided.
let me answer my question first, please. Did I miss that? Did you have experts to suggest that the science has changed and that's why Schultes is no longer applicable? Because if you did, I missed it. Perhaps I when I was reading, I missed it.
Well, it's a different disease, Your Honor. So
I know what
Schultes-
mesothelioma is. I also know what angiosarcoma is and all the effects of asbestos. However, I didn't see anything in the testimony that would suggest to a judge that he or she could ignore Schultes from your experts.
Sure. Well, our expert in occupational medicine did testify that people with very short exposures to asbestos can develop mesothelioma. And again, that was recognized by the appellate division in the Kurak case, which I do think modifies Schultes to account for the difference between asbestosis, where frequency, regularity are relevant, and mesothelioma, where, as the court noted, if a few fibers can cause it, then the jury can find that that was the cause. So Kurak is an important modification of Schultes.
But frequency and regularity, you can have a different gradations of frequency, regularity, and proximity that can meet the substantial factor test. But tell me if I'm wrong, I thought that our law was, after Schultes and James, that in all occupational exposure cases, the jury simply was not thrown in there with substantial factor, but was guided to think about the frequency and the regularity of exposure and the proximity of the person to the exposure based on the recognition in the Schultes case by the appellate division, ultimately this court in James, that those factors in a workplace setting matter. Now, they may matter in a different way in different workplaces, but they still are relevant. And that's why I was really surprised to see an argument that Schultes doesn't apply if the disease is mesothelioma, when it's a very common tragic disease. It's very common in these cases. And the idea that Schultes goes away because it's mesothelioma was just news to me. And obviously your adversary says it doesn't, and the appellate division says it doesn't.
Well, it was implied as a summary judgment standard in this case by the appellate division in 2017. There is no way to take that standard and translate it to jury instructions in a way that will be meaningful and not invite error. When the
appellate division applied Schultes to your case, did you say, wait a minute, Schultes is out of this?
We argued that it was modified by Kurak because it's a mesothelioma case. But when you get to the question of crafting jury instructions and whether the trial court erred in giving the model jury instruction instead of the frequency, regularity, proximity, it's a different question. And when we're talking about mesothelioma that can be caused by only a few fibers, short, minimal exposures, how can, when courts do this analysis, any opinion you read that's doing this analysis cites to various opinions of the appellate division, this court, appellate courts from other jurisdictions, where they look at very specific factual situations. This person worked here 10 months. He was in this room for, 30% of the time. Is that enough exposure? And they go through that analysis. And that type of judicial analysis just does not lend itself to instructions and definitions that can be included in jury instructions.
Why
How do
is
we
that? Because
explain to a jury?
your expert, I'm sure was very effective, said that only a minimal amount of exposure in this particular setting would be appropriate. And that obviously there's conflicts of experts in this type of case, right? Presumably an expert on the other side would say it takes longer and consistent and so forth. What is so wrong with a jury being asked to consider those three features of the exposure, which Schultes and James said were the guiding law, when the jury's asked to deal with complex questions of medical causation all the time? Why should the jury just have substantial factor thrown at it when our law is that these three considerations have to frame the issue?
Well, because, Your Honor, I don't know how you could craft instruction, because just saying to a jury, you have to find that the plaintiff was exposed with sufficient regularity, proximity, and frequency. How does a jury know what sufficient regularity is? If the court just leaves it there.
Your experts inform the jury.
Sure, but if you're going to give the Schultes language, then I think you at the very least have to include the language from Curach that says, if the evidence proves that one fiber can cause the disease, then you may find causation. And so if you're going to include case law and language from one case, and that case has been modified in the instance of mesothelioma by another case, then you can't include only the first case language. You have to include language from Curach and other cases.
The judge, tell me if I'm mistaken, in the charge of the jury, the judge was very careful to ensure that the jury knew that unless the exposure was a substantial factor, that was the end of the story. And it gave language about like what wouldn't be a substantial factor, sort of like minimal or whatever. I don't have the charge directly in front of me, but it actually, when you look at the charge, it doesn't look all that much different from Schultes, quite frankly, parts of it. Am I off? I don't know if you have it in front of you.
No, that's right, Your Honor. The jury, in addition to the model civil jury charge 6.12, the court included at Union Carbide's request language from Curach that said liability should not attach based on casual or minimal contact with the product. Liability should not be imposed on mere guesswork. So the court did take additional language to let the jury know that in order to be a substantial factor, it could not be casual or minimal contact, and that the liability cannot be imposed on mere guesswork. So there was additional language to protect Union Carbide from a jury assigning liability based on casual or minimal contact to their asbestos. And I note that in this case, to the extent the court's looking at the specifics of this case and the charge in this case, we don't think it's appropriate for a jury charge for mesothelioma at all. But in this case, this was not a close case on the Schultes factors. This is not an instance, even in 2017, when the appellate division addressed the grant of summary judgment and reversed it, the appellate division compared Mr. Edenfield's exposures to what was present in Curach and the Goss case, which was cited by Union Carbide, and noted that here the plaintiff decedent regularly scooped, weighed, and mixed ingredients, including asbestos.
So you're saying you would win.
Carbide,
you're saying factually you would win if the Schultes, if the jury was instructed that it was your burden, as to use James's language, a plaintiff may demonstrate medical causation by establishing factual proof of the plaintiff's frequent, regular, and proximate exposure to defendant's products. You're saying you would win that?
I'm saying that even if there was some error in the charge, it was harmless in this instance because of the facts of the case. But again, I don't think that the jury charge is appropriate in the first place. One
It
other
seems
note
to me that Schultes, one of its purposes was to ensure that casual minimal contact did not result in a finding of proximate cause.
correct.
But you're saying that,
And Union
you had
Carbide
an expert who
received the
said
benefit.
that casual minimum contact could satisfy the proximate cause.
Well, again, in Curac, the court said that de minimis exposure can cause mesothelioma. Now, there's a difference between de minimis exposure and casual contact. But again, that language was in there for the benefit of Union Carbide. And so they did have language that let the jury know that there had to be a certain level beyond casual minimal contact in order for them to find proximate cause. But the sufficient frequency, regularity, proximity would not have added anything to that charge. It only would have confused the jury.
Are juries charged as to Schultes in a non-asbestos, non-mesothelioma cases that don't involve asbestos?
In doing the research for this case, Your Honor, I found no cases where the Schultes language was used as a jury charge and then had become an issue in a case. So I can't profess familiarity with the jury charges in non-asbestos toxic tort cases in New Jersey, but it certainly has not raised to either a published opinion from a trial court or the appellate level. And Union Carbide,
all it's being used as is a summary judgment standard?
It's being used as a summary judgment standard and as a standard to review verdicts to see if they are against the weight of the evidence. So it's used both in the beginning and the end stage, to review verdicts, which protects defendants from prejudice if they feel that a jury, that the evidence doesn't rise to the level of significant frequency, proximity, regularity, based on comparing the exposure in the case to prior cases, they cannot let it go to the jury. But again, I have not seen any case where it discussed the Schultes language, which was adopted in 1989, being used in a jury charge. And of course, there are methods for changing and adopting new jury charges. Again, Schultes has been in force since 1993. And if the proximate cause jury charge needed to be amended in toxic torts to include that language, there is a process for doing that, and that has not been done. And at the time that this trial judge gave this jury instruction, she followed the model jury charges. She followed the Richter court, the panel of Richter in 1995, which said it would be error in a mesothelioma case to give the frequency, regularity, proximity language. And
so
the
cases that are cited by the defendant, again, they're mesothelioma cases in which Schultes is being used as the standard, right? There are a number of appellate division cases, nothing from this court.
Correct. They would be cases where it's being used as to either judge the summary judgment grant or denial, or to review a verdict. And again, anything decided since Curac, which was decided just the year after Schultes, generally any mesothelioma case that discusses Schultes also discusses Curac because of its recognition that mesothelioma is different than asbestosis or lung cancer.
Sloan, we're coming up on an hour. I wanted to give you a few minutes if you wanted to wrap up, or anybody else has any questions.
My doing, Chief.
All good.
Sure. I would just, on a final point on the medical causation charge, this court has held that it is difficult to find that a charge that follows the model charge closely constitutes plain error. And it is discussed that the process that leads to the model jury charges is thorough and comprehensive, and that the charges are reviewed and refined by experienced jurists and lawyers. And that comes from State BRB and the quote about it being difficult to find that a charge that follows the model charge closely constitutes plain error is from the Mogul case. The purpose of these model charges is to provide trial courts with guidance and consistency when they're instructing juries. And the trial court here followed her practice since she's been the MCL asbestos judge, her determination, having overseen several of these trials, that this language is not necessary and will confuse the jury. And an appellate division decision going back to 1993 that she was, or 1995, that her instruction was in accordance with.
Ms. Long, this was not a plain, this isn't a plain error case, is it? I thought that there was quite a bit in the transcript where the defendant was disputing the jury charge.
They did
It's not plain error. It's not plain error. Is it plain error would be if the defendant didn't object, if the defendant didn't seek another jury charge, et cetera?
No, correct. She had to give a correct statement of the law, Your Honor. And I
No,
believe that
I'm
she
sorry,
did.
just to be clear, the standard of review on this issue is not plain error, is it?
No, not to the extent that Union Carbide did challenge the instruction at the time. They
Okay.
preserved the issue.
Thank you.
But I would state that the judge followed the law. She followed the precedent in mesothelioma trials, that in her considered judgment and the judgment of prior asbestos MCL judges, that this instruction was unnecessary and would have confused the jury. And the court should find that she was correct in giving that instruction and reverse the appellate division's vacation of the verdict. Thank you.
Ms. Long. Mr. Placatello.
Good afternoon, Justices, and may it please the court. Thank you for permitting the NJCJI the opportunity to appear and argue as a friend of the court. We would like to address 2 points today. First, why a manufacturer cannot rely on an employer to act as an intermediary to warn the end user employee. And second, why the Schultes frequency, regularity, and proximity test is best applied by the trial judge in its gatekeeping function to determine whether there is sufficient evidence for the jury to consider medical causation, rather than an instruction to the jury to evaluate proximate cause. There are also 3 basic rules that apply to a strict product liability claim for failure to warn. The first is if a product is not reasonably safe for its intended purpose, then the manufacturer must warn of the product's dangers and inform how to use the product safely. Second, for that warning to be adequate, it must be communicated by the manufacturer to the end user. And third, if the manufacturer fails to communicate the product's dangers and safe use to the end user, then its product is defective. Those principles apply whether the manufacturer chooses to sell its product to be used by consumers or in the workplace. Indeed, decades of this court's precedent has established that if a manufacturer chooses to sell a dangerous product to be used in the workplace, then it has a non-delegable duty to warn the end user employee. And by definition, non-delegable means an obligation that cannot be handed over to another person to be performed. We submit, Justices, that the appellate division here erred because it determined that the jury should have considered Union Carbide's communications with the plaintiff's employer, even though the jury found that the warning it did communicate to the plaintiff did not adequately inform him of the dangers and safe use of the product. Union Carbide's communications with the employer are irrelevant to whether the product at issue, bags of raw asbestos, are not reasonably safe, and they are immaterial to whether Union Carbide fulfilled its duty to warn because those communications were not provided to the end user.
Mr. Placatella, how can you say that it's utterly irrelevant what was given to what information was given to the employer when there's Kaufman and there's Thier, and now there's the restatement, which all make the information given to the employer relevant. Now, where it fits into the total picture here is a separate question, but you're making, I think you're even going beyond what your co-counsel is saying by saying that the employer's warnings to that the manufacturer's warnings to the employer are irrelevant.
Well, Your Honor, they're irrelevant to the extent if they do not reach the end user. So whether communications from the manufacturer to the employer are admissible, relevant, depends, on any given case.
Okay,
But-
and that seems to be what the appellate division is saying. We don't know in cases, especially where sadly the person is deceased or the time period is many decades ago, we may not know all the facts. But our law very solidly says that this is relevant, that these warnings are potentially relevant. If you find out in a particular facts that they didn't really send them or whatever, you may, I'm not suggesting it would be there, but that issue is relevant. It's in Kaufman, it's in Thier. There's just been consistent law on that. And it seems to me the purpose of that is to incentivize manufacturers to go through two tracks. One, the package warnings, and the other going through the employer to see if more detailed information could be provided. So do you really mean to tell us that we should say, manufacturer, just skip it? It's irrelevant what you tell the employer.
Not at all, Your Honor. We want to incentivize as many avenues of warnings to employees as possible.
Yes.
But what happened in this case was the jury found that the warning that was given to the worker was inadequate and that did not adequately inform him of the dangers of the product and its safe use. The manufacturer cannot be absolved of liability because it took some steps to warn the employer. Now, the duty to warn the employer is in service of the duty to warn the employee. If the manufacturer cannot assure that the dangers of its product are transmitted to the one who's actually using it, then it's not relevant to whether the product itself or the warning on the product is sufficient or adequate.
But if you're saying that unless the manufacturer is essentially in the plant and can subjectively know that the warnings are being delivered, it's not going to help it in a product liability case. It seems to me you are discouraging, and I'm not saying, obviously these asbestos cases are from a time many years ago, but if that's the statement of the law you want us to give, I would suggest that the policy consideration of incentivizing careful warnings is not being served.
Well, Your Honor, I would kind of flip that around. I think the principle that we're advancing is supported by the case law and would incentivize good policy. As this court has said at first with Dexiga and has followed with Machalko, Stevenson, a manufacturer has a duty to employees of the purchaser to correct a product defect and may not rely on the purchaser employer to make the necessary correction. And this court said in Kaufman, a manufacturer cannot escape its duty to employees by merely sending a warning letter and a new safety device to be installed on the machine.
We're talking about safety device issues. Respectfully, I think safety devices, which were the focus of so much development of the law especially in the 1970s, present a special set of facts where you have employers who were removing safety devices. A lot of concerns here that I think when you're dealing with an occupational danger like this, those safety device cases are not the most relevant. I think, obviously Kaufman and Thier recognize that information provided to the employers is important, but I just really want to reiterate, if you're telling us it's irrelevant, that to me is just inconsistent with the way that issue's been handled.
It's only irrelevant if the warning does not reach the end user. First and foremost, the worker needs to be warned. Merely warning the employer without any proof or assurance by the manufacturer that that warning actually reaches the employee is irrelevant. So the steps that a manufacturer must take to communicate the warning to the employee will be commensurate with the foreseeable risk
Right.
and the use of the product. So
And
first,
that's what this jury instruction under 3B was, right? It was about whether the manufacturer took reasonable steps to ensure that the information went to the employees.
well, Your Honor, I think the way that reasonableness in the discussion with the petitioner's counsel was framed, I'm not sure is correct. Whether a manufacturer's conduct is reasonable is irrelevant whether the warning adequately informed the end user of the dangers and safe use. So the focus of strict liability law has always been on the safety of the product rather than the reasonableness of the manufacturer's conduct. And to the extent that that reasonableness is to be considered in a failure to warn case, it's to use to assess the adequacy of the warning. Does the warning effectively communicate the dangers and safe use?
This two-pronged thing, and I'm just looking at the verdict sheet, and which seems to reflect our case law, Kaufman. Had the plaintiff failed to show that the warnings were inadequate and also failed to show that Union Carbide failed to take reasonable steps, that would have been the end of the game.
Correct, Your Honor.
If that were the case. But even if the warnings were adequate, the failure to properly advise the failure of Union Carbide to take reasonable steps to ensure that its warnings reached Edenfield, that would still potentially make Union Carbide liable. And that's precisely what Kaufman wanted. They wanted the warnings to go to the employee and to the employer. No skipping. If you fail on one, you still may be liable. Am I mistaken in terms of the way I'm reading Kaufman and our jurisprudence? Go ahead.
You're not mistaken, Your Honor, because the law wants to incentivize, to Justice Patterson's point, as many avenues of warning the end user as possible. But when you evaluate the adequacy of the warning and whether it informs the person who's handling the product, of the risks and dangers, was it plaintiff's
burden? Was it plaintiff's burden to show to prove by preponderance of the evidence that the defendant did not use reasonable steps?
No, Your Honor. I think the burden on the plaintiff would be to show that the warning to Mr. Edenfield was not there or inadequate.
So you're saying that this is a two-pronged test. There's the plaintiff's burden on the first prong, but it's the defendant's burden on the second?
Well, no, Your Honor. I mean, I think the plaintiff has to show that the warning goes to the employer and employee. I don't think there's a shifting burden that goes to the defendant. But what the law does not contemplate is that an employer's what happened here in the appellate division, why it's troubling and could have very slippery slope consequences, is that in finding that the jury the jury found that the warning to the plaintiff was inadequate. The appellate division said that doesn't matter. The jury should have considered communications to Union Carbide when there is no proof that those warnings to Union Carbide ever went to the plaintiff. So if that were the case, and a manufacturer could supply no warning or an inadequate warning to the plaintiff and still be absolved of liability by communicating warnings only to the employer, then there would be no assurance that the end user would actually receive the warning. And our law does not contemplate that.
You're saying that the burden that the defendant must prove that the employer provided the warnings to the plaintiff?
They have to, the defendant has to defend the case. The plaintiff has to show that the warning was inadequate and was not received by the plaintiff. Does that address your question, Your
And,
Honor?
and when you have a case like this, which is a common scenario where no one really knows what the plaintiff received or didn't receive, the decedent, is it the plaintiff's burden to prove that the warnings did not, the employer warnings did not reach the plaintiff?
Well,
It's the plaintiff's
No.
burden. I mean, what I'm getting at here is you have a jury instruction that goes in kind of two different directions in terms of how it's phrased. What is this thing about reasonable steps if it isn't the burden on the plaintiff to prove that the steps taken were unreasonable and that unreasonableness caused the exposure, leaving all the burden on the plaintiff the whole time? It seems like what you're saying is there's some aspect of this that's the defendant's burden, and I think it's a confusing scenario.
no, Your Honor, what we're advocating is merely that the warning needs to be received by the plaintiff. So in
But
this case.
whose burden to prove that? Whose burden is it to prove that? The
Well, in this case,
defendant
Your
or
Honor,
the
it's-
plaintiff?
There has to be a duty to warn both
No,
the
no, you haven't
employer
answered
and
my
employee.
question, please.
And whose
My
burden
question
was
is
it?
very simple, counsel. Whose
Sure.
burden is it to prove what you just said? Is it the defendant's or the plaintiff's?
It's the plaintiff's burden to prove that there was no warning to the plaintiff and the employer. But Your Honor, what happened in this case.
Counsel, before you jump into that, and we appreciate your help as amicus here. I'm mindful of the hour and want to give Mr. Scodro an opportunity to speak as well. So plan on an additional 5 minutes to cover your point and medical causation as well, please.
Your Honor, I'll move to medical causation given the time, and I appreciate the opportunity on behalf of NJCJI. The Schultes frequency, regularity, and proximity test is best applied by the trial judge in its gatekeeping function. Trial judges act as gatekeepers to determine whether there's sufficient evidence for jurors to evaluate certain issues. Trial judges decide whether there are genuine issues of material fact for a jury to determine. They determine whether the plaintiff has presented sufficient evidence to sustain a verdict. They determine whether the expert's methodology is sufficiently reliable. And they hold 104 hearings to determine whether there is sufficient factual basis for certain evidence to be admissible. And as the counsel for the plaintiff petitioner alluded to, for the last 3 decades, judges in the asbestos MCL have used the Schultes test to determine whether there is sufficient evidence of asbestos exposure to a defendant's product for the jury to consider medical causation. And based on the earlier colloquy, it was under the impression that judges are ignoring the Schultes test. They are not. As it's shown in even the procedural history of this case, judges apply the Schultes test to determine whether there is sufficient evidence of exposure. And then if that passes the gatekeeping, it is the jury's determination to figure out whether that exposure was a substantial factor in causing disease.
So is it the NJCJI's position that Schultes is the governing test in a mesothelioma case?
Schultes is modified by CURAC, which counsel for petitioner had said, so there is a different standard for mesothelioma cases because of the scientific evidence showing the lesser exposure to asbestos that is needed. But even the Schultes test imagined that the jury would be the one who would be determining substantial factor. That case says, quote, the issues, quote, are best resolved by reference to the concept of proximate cause. The contact between a plaintiff and a defective product must be sufficiently significant so that a reasonable jury could determine that a product was a substantial factor in bringing about the plaintiff's harm, close quote. And that is why, to Justice Albin's point earlier, that's why the appellate division in Richter held that the model jury charge a substantial factor instruction properly applies the concept underlying the Schultes test. And unlike the Schultes, the substantial factor test that is well-defined and has been applied by our juries, not just in toxic tort cases, but in cases where there are multiple tortfeasors that contribute to a plaintiff's harm, there are no well-defined terms for what is frequent, regular, proximate for the jury to consider. And those terms, which the Schultes court did not want to be used as catchphrases, turn on the toxinant issue and the means, duration, and length of exposure. If this court were to hold otherwise, that a jury should be instructed on the frequent, regular, approximate test, then it should refer the matter to the Model Civil Jury Charge Committee to further consider how to best aid and instruct the jury in consideration of these issues. Unless the justices have any further questions, I'm going to rest.
Thank you, Mr. Placitella. Mr. Scodro.
Thank you, Your Honor, and may it please the court and counsel. If I could, I'll try to use my opening remarks to frame the issue that I think is before the court and to explain a couple of things that I fear may, that I would disagree with, certainly in the way they've been presented by petitioners counsel in the case and in their briefing and today, and that namely the effect that the two rules, the competing rules here would have on the safety measures that would be incentivized. And also talk a little bit about this notion that in strict liability, somehow the test announced in Kaufman and in the restatement and others, which are strict liability statements, does not apply. It is a reasonable step standard, I think, as Justice Patterson had asked about earlier. So I'll begin by saying that as I think has become clear and was clear in the briefs, plaintiffs here seek and require an unyielding rule that the trial court applied in this case. That is, that there is a freestanding duty to provide a complete and independently adequate warning on the face of the packaging. If there's any exception to that, then Union Carbide is entitled to a new trial. Under plaintiff's rule, the jury may not consider anything else, full stop, in deciding whether the manufacturer has discharged its duty to warn the employer. Again, there's no authority for this rule. It defies the restatement. It defies the law in other jurisdictions and New Jersey precedent, as we explain in our brief. Like the restatement, this court has recognized in Kaufman that discharging the duty to warn the employee sometimes requires communicating information through the employer. And Greer made that holding express. Now, this rule makes practical sense and can do more ultimately to help employees. Why should product packaging itself and alone receive an arbitrary and unique status as grounds for a freestanding duty, particularly when we know from the science and the literature, we know from the record in this case that in modern plants, they are rarely seen by the employees, and even rarer still do they read the warnings on the packages. As Kaufman, Greer, and the restatement and other jurisdictions all recognize, what matters is the reasonableness of the manufacturer's effort to meaningfully alert its customers' employees to the product dangers and to propose ways to use that product safely. This is not a delegation of the duty to warn employees. It's the creation of warnings that go beyond the bag, including some like posters or pamphlets where appropriate, that must, as a practical matter, be passed through the employer. The manufacturer can't put posters on walls or brochures in employee hands without trespassing. They have to pass them through the employer. Plaintiff also misunderstands the practical effect of these competing rules. Plaintiff suggests that by rejecting the restatement rule and converting the well-recognized duty to warn employees into an unprecedented and drastically narrowed duty to put all employee warnings on the bag, this court would actually incentivize manufacturers. They claim it would incentivize them to maximize warning, but that's not true. Under plaintiff's proposed rule, manufacturers, again, have to put everything on the bag. Isn't it a better incentive to manufacturers to create and to pass along alternative and superior measures designed to talk to the employee, things like posters or brochures, manufacturer-sponsored training? Isn't it a better incentive to create those or incentivize those by crediting that and counting it when jurors are charged to determine whether the manufacturer has discharged its duty to warn the employee? And nor is there anything to the distinction that plaintiffs and their amicus try to draw between so-called direct and indirect communication. The words have even been used a bit today, between manufacturers and their customers' employees. And what about the operations manual in Greer? Now, that's no more or less direct than the pamphlets that Union Carbide provided here. Both were given to the employer, but intended for the user. And what happens if, as we know is often the case, the material is provided in bulk? So there's no packaging. Is a warning material that accompanies the product, but again, has to be given in the first instance to the employer, even though it's meant for the employees. Is that being communicated directly or indirectly within plaintiff's view? It simply isn't a workable distinction. And finally, on that point, I'll just note that although there were cases cited in some of the later filed briefs in response to amici by the plaintiff, cases like Feldman and Freund, for this proposition that somehow we only look at the product, that is to say, we're not looking, contrary to Kaufman, contrary to restatement, we're not looking at whether the manufacturer took reasonable steps to convey the warning to employees. Here, for example, by sending posters and so forth. That's simply contradicted by those own cases. Reading further down in those same cases, they say, here's what we mean by that. We mean that in the strict liability context, the manufacturer is presumed to know of the product's dangers. We still then, those cases still go on to say, just as Kaufman and the restatement do, that in the strict liability context, the lodestar question and the one before the court, the question, or that should have been before the jury here, is were reasonable steps taken by the manufacturer to ensure that employees were properly warned? And here, that ought to have included looking at all of the material that was given to the employer with the express direction in some cases to just hand this over to the employees. And I should note to this, the notion that somehow this is absolving the manufacturer, or it's washing its hands, or it doesn't run the risk that the employer will just put this stuff in a desk drawer. It simply isn't true. The restatement test itself allows for jurors to balance a number of factors in deciding whether it was reasonable to ask the employer under those circumstances to pass material or information along. And if there's a claim made that that's simply unreasonable under the circumstances or in this industry or what have you, if that would be the plaintiff's argument, that's an argument for the jury in deciding whether it was reasonable or unreasonable under the circumstances. Your Honor, I'll very quickly just touch on the second, but obviously then, I'm happy to.
Have you finished your opening statement, Mr. Scodro?
I have as to the first issue, Your Honor. I'm happy to pivot to the second or to wait, and we can deal with that separately. Whatever the court prefers.
If you inviting questions,
please.
Okay. How does the manner in which the obligation of the manufacturer to warn the employer and the relevancy determinations that were made by the trial court here differ from the restatement approach?
Well, the difference, Your Honor, I think is fairly encapsulated in the, if I looking at the jury instructions, the following, if I may quote just one sentence from the jury instructions: the duty to put an adequate warning on the product may not be discharged by warnings and information to the employer. This presumes that there is a freestanding duty to put an entire warning on the product. And in context, of course, in light of closing arguments, and certainly in light of the jury's question and the answer the court gave, it was very clear that what this means is there is a freestanding duty to, and I think it's the one that's been talked about today and the petitioner is openly advancing, a freestanding duty to include everything that's needed for an adequate warning to the employee on the package, that nothing else counts as direct. Perhaps putting something on the outside of the bag would count as direct. Again, as I stated, I think there'd be a very tough line to draw if we start talking about what's direct and indirect communication. That differs because the restatement says outright, there is no hard and fast rule.
Yeah, so I'm looking at Kaufman, because that's our law. And Kaufman says there's an obligation to warn both the employee and the employer. All of the things that you said about transmitting information to the employer, so we'll get to the employee, makes a whole lot of sense. And I think we'll protect manufacturers and also we'll protect employees as well. But Kaufman talks about direct communication with the employee. And in this particular case, we know that there are bags of asbestos. which are dangerous. And plaintiff is saying, and says they have proved before the jury, that the failure to put adequate warnings on those bags themselves violated the common law duty of the manufacturer, and that's precisely what the jury found. So like, why has the plaintiff satisfied that prong?
Sure. The reason, Your Honor, is that they chose the bags alone. There's nothing in Kaufman. In fact, Kaufman is to the contrary. There's nothing in Kaufman that says, by the way, the only way to do this, to discharge, you're putting aside any duty to the employer, and I understand the discussion about concurrent duties and so forth that Thier discusses, but the duty to discharge, discharging your duty as a manufacturer to the employee, Kaufman doesn't say the only way to do that is on a bag. What it says is you have to take reasonable steps to ensure that you are warning the employee. And as the restatement correctly expands, but this is perfectly in step with Kaufman, there might be many ways to do that. And we should incentivize manufacturers to do it in the way that's best. We know
So
that.
let's take what you've just said. The bag is one way of directly informing the employee. Tell me how Union Carbide directly, if it didn't do it through the bag, how did you directly communicate to the employee? Forget about the employer, okay? Because your reasonable steps to the employer, that's a separate problem. Tell us what you did to communicate directly with Edenfield.
Communicating, and again, I just want to give pause to the directly, indirectly, because I'm not entirely sure where that line is drawn. But I will say that in giving the warning on the bag may or may not have directly reached.
Forget about on the bag, okay, for the second, because you're saying maybe not the bag. Let's talk about plastering the wall with warnings, with skull and crossbones, or on pillars, or on the floor, or whatever. Did you do any of that?
We gave the employer everything it needed to do exactly everything we could short of trespass.
That's
Mr. Scodro, does a vendor have the right to go in and plaster signs? Plants may have 100 vendors, right, or more. Does a vendor have the legal right to go in and plaster the walls, plaster pillars, plaster things all over the place in a plant?
We don't, Your Honor. And
so what you can ask, if you don't want to put it on the bag, you could ask permission. Can I come in and put it there? No?
Well, Your Honor, what we did in this case, Justice Albin, is we asked them in the letters that are in the record, we said, hand these out, make sure we can get you enough for every employee, for example. And the brochures, as you'll see in the appendix.
So I understand. I'm not saying that you didn't make reasonable efforts to communicate with the employer. On the verdict sheet, it indicates the plaintiff didn't prove that. But Kaufman says you've got to communicate with the employee. And Kaufman specifically says, like, one of the reasons why you do that is because we're not always certain that the employer is going to communicate the correct information to the employee. So that's why there is this dual requirement. Correct? Am I mistaken? Am I reading it, Kaufman?
No, Your Honor, not mistaken, but let me just qualify it, if I may. What Kaufman is saying, as I understand it, is the ultimate duty is to the employee. We all agreed earlier, I think in an earlier colloquy, that the lodestar here is that the employee at the end of the day receive adequate warnings. Kaufman recognizes multiple channels to do that. Plaintiff's effort here, this goes far beyond Kaufman, and indeed we would say disagree, conflicts with Kaufman, is to say, and the only way, we're going to shave these in two, but the only way you can satisfy channel one, which is communication with the employee, is to put something on a bag that we know in the modern environment frequently is never seen by employees.
Did you put warnings on the bags?
We did, Your Honor. Yes.
So you obviously thought that putting warnings on the bags were going to accomplish something, but the jury just found that those warnings were inadequate. It's not like you didn't think that the bags would communicate the information. You did. The jury found they were inadequate.
But, and Your Honor, the jury, if they were asked to focus on any single factor posters, they might have found those alone were inadequate. The brochures we sent, they might have found those alone were inadequate. I don't know. I hope not. But the point is
there any way to communicate? An MSDS may be very multiple pages of explanations and training and some quite complex medical considerations that are communicated. Can that be put on a 10-pound bag of asbestos?
It can't, Your Honor, even if we thought employees would regularly see bags, and we know that's not the case, and we know sometimes this stuff comes in bulk, so there are no bags, which means this can't be what the law requires in every case.
And posters use big print. They have symbols. I didn't know what the particular posters, but they can create with some drama as to the need to take precautions around the product. Is that something that can just be put on the bag?
Not on a bag of this size effectively, Your Honor. And I would add that if Your Honor looks at the examples provided in the appendix to our opening brief before the appellate division, there are numerous examples of exactly what Your Honor is describing. These are very stark. They're posters that show images with very precise warnings. Likewise, with the brochures that were intended to go to employees directly, directly, that is to say, please give these to the employees because we can't come in and do it ourselves. Those also had images and very clear instructions, things like do not sweep dry, make sure it's wet or vacuum, things that you can take, and there are many of these, right? And so this was the literature.
I thought that the plaintiff's argument, and tell me if I'm mistaken, was not that there had to be like paragraph after paragraph on the bag, is that you didn't put the information, however little it would have been, to apprise the worker of how really dangerous this stuff was. And that the exposure of a small amount might be life-threatening down the line, even if it was just in a couple of lines. That's what I thought. That's what they were arguing on the bag.
2 points, Your Honor. I appreciate that. The first point is I'm not sure that's what they're arguing in their briefs. That's to me that it strikes me that the position that they're taking is that there needed to be full and complete warnings on the bags. And that if that was the only thing an employee ever saw, that would be enough to adequately warn them. But I'll say more importantly, the questions Your Honor is raising, including this question, I think this is precisely why this is a jury question. What the restatement and other courts have recognized is that the question is, were reasonable steps taken? And Kaufman echoes precisely that standard. And that is a classic jury question. And if part of the answer is, look, if you look at what was on this bag, and then you compare it to what's been provided to the employee, and the employee has a history of not passing along warnings or whatever, you might say that's a closing argument.
But the jury was given. If those warnings were reasonable and adequate, if they were adequate and reasonable, then there would have been no liability. That went to the jury. The jury could have determined that, yeah, these were adequate warnings. They were put on notice.
Honestly, actually here they didn't, Your Honor. All the jury got was, they had to answer was the threshold question, was the jury, was the bag itself, was the warning on the bag itself adequate? And we've heard counsel answer directly and correctly, consistent with their position this morning, repeatedly, that if the warning on the bag itself was inadequate, then everything comes to a stop.
Yeah, as I understand the way this was set up for the jury, and that's why I was frankly really befuddled looking at the way this thing was set up, was that there's a question only about the bags, and then there's a question about reasonable steps. But the position, I think, what the jury was guided to do is the whole ball game is on the adequacy of the warning on the bags. And even some discussion today talked about even if the warning is inadequate on the bags, all this other stuff doesn't matter. That is really far from not only the way the law is recently developed as expressed in the restatement, but from Kaufman and Thier and the appellate division's opinion in Greer, isn't it?
It is, Your Honor. And as we say in our brief, and plaintiffs haven't come up with a case to the contrary, we have yet to see a case in any jurisdiction that says that everything turns on what is on the bag when it comes to discharging the duty to the employee.
So then when the appellate division looked at this, and they recite the restatement and they cite the law, that what they were saying is, yes, it matters what's on the bag, but it also matters about these other steps that were taken that in this case, the jury found reasonable. And the entire consideration for the jury should be an integration of those together, not have one question that matters and one question that has like evaporates into the air as irrelevant. I mean, isn't that what the appellate division was doing here?
That's my reading of the appellate division, Your Honor. It's precisely what we asked of the appellate division. It's what we believe Kaufman, and certainly we know the restatement demands. And that's exactly what we've asked for.
Well, Kaufman, the direct communication to the employee in this case is through the bag. And why? Because this is the item that the employee used every day, every week, every month for years. He was grabbing it. And the question is, were the warnings on the bags inadequate to apprise him and others of the dangers to which they were exposed?
And thank you. Two quick points in response. First, we actually don't know. We know that bags routinely are not handled by most of the employees dealing with the substances. We see that in the literature. And actually on this record, I know there's been some questions on this. It is unclear, it is disputed whether or not there was no direct evidence from Mr. Dover or anyone else that Mr. Edenfield handled the bags of collyrdry, that those were being handled in his part of the milling room and so forth. So I think the premise that is a more direct way to speak to employees than, say, a poster, I think that premise is simply incorrect factually. But the other point is Kaufman, as I see it, is not relying on a distinction between direct and indirect. It's relying on a duty to warn employees and a duty to warn employers. It recognizes both, although the second is in service of the first, to be sure.
In fact, isn't it fair to say that this distinction between a direct warning, obviously, if you have a retail consumer product and it's a pack of cigarettes, it's cold medicine, it's going directly to the consumer, it's in a packaging, you know the consumer is getting the packaging, whether they read the warning or not is another thing, but at least they have it. But it seems to me the appellate division was trying to convey that in an industrial setting, you don't know exactly what the employee is seeing and doing every day. And therefore, you want to incentivize multiple channels of information in the good faith hope that multiple ways the message will be conveyed. And it seems that the trial court was just saying the ball game is entirely on the package, which ensures that only very few words are even going to be given.
Agreed entirely, Your Honor. And I think what the restatement and I would argue Kaufman and certainly the other jurisdictions, what they recognize is exactly what Your Honor said. Different environments are different. And it is up to a jury. It should be in the province of the jury. We should count on the jury. We all agree it's a reasonable step standard. That's right in the face of Kaufman, and it's in the restatement and so forth. It ought to be up to the jury to determine whether the efforts taken were reasonable, and up to the plaintiff may argue, hey, look, under these circumstances, the only reasonable way you could have communicated was through the bag. And that would be part of their closing argument.
But the second part, and that is providing reasonable information to the employer, doesn't answer the question whether it gets to the end user. The first question immediately gets you to the end user, whether or not there was an adequate warning. And even in these asbestos cases, at least some of the cases that I'm aware of, including Wheelan, the warnings are put on the products. They're put right there on the products, warning the worker whether or not the machinery or a part of the machinery contains asbestos that could be dangerous. Am I mistaken?
I want to make sure I'm answering your Honor's question correctly,
Go ahead.
understanding it correctly. If the question is, are there cases in which there are warnings posted on, say, a piece of machinery about the dangers?
Yes.
To be sure that
On the boxes, on the machines that are being opened by the workers. That's where the manufacturer puts the warnings. That's where you put the warning. You put the warning on the bag. And now you're saying, well, even if that's not any good, maybe they got the information somewhere else.
So no, Your Honor, let me be clear. We're not saying maybe they got it somewhere else. That is true, by the way, of some of the cases that when, for example, the Olenki case that is cited as a New Jersey unpublished decision, I believe, or the New Jersey decision rejecting the notion of a sort of learned intermediary. That's a case where the effort was made by the defendant to say, hey, RCA, you're smart. We may not be putting anything on the machine or the package, but we're going to count on you to make sure this is passed along. Far from it here. The restatement rule and the rule applied in other jurisdictions, and I think this is exactly what Kaufman was driving at, is no, look, we have an acknowledged duty to warn the employee of the dangers of the product. The question the jury has to decide is, so there's one option, which is, as a matter of law, the way to discharge that duty is what you put on the bag, full stop. That was what was applied by the trial court here. What Kaufman's saying, what the restatement is saying is, we have to consider the circumstances. And is this a circumstance in which the best way to do that is the box? The best way is the box combined with posters handed to the employee to put on walls? Or is it coming in and doing live training in conjunction by the manufacturer? These are the things that the restatement rule permits the jury to consider. And obviously,
so in Wayland, for example, he's installing boilers. He's taking boilers out of boxes. Presumably, he can't do his job without handling the box. Maybe a very effective way of doing that. But what you're saying is, when you're dealing with the actual asbestos in bags, the bag is a hit or miss.
The bag is a hit or miss, Your Honor. Even
and
if
it really is no inherent distinction between warning on bag goes to employer, handed maybe to employee, and other information goes to employer and maybe at the urging of the manufacturer handed to the employee.
That's exactly right, Your Honor. I mean, you could put the largest warning on a bag, and if the employer process is to have those unloaded at the dock and put into, buckets and bushels and so forth that then proceed through the plant.
You may be right. Maybe he won't, but that is an effort. And here the jury found whatever you put on the bag was inadequate. You're saying, well, he may not see the bag. Someone else may see the bag. But if he saw the bag, or if his co-employees saw the bag, or his other co-employees saw the bag, they wouldn't have the proper information. That's what the jury found. It was inadequate.
Because you're right, Your Honor, because they were limited to saying, just as if they had been arbitrarily limited to, well, let's just look at the poster options, or let's just look at the brochures that had been offered. Let's just look at the MSDSs. But none of those constitute the universe of material provided and intended for consumption by the employees in this case. And so by being artificially limited to one of the many ways in which the manufacturer here was trying to communicate to the employee, by looking at only one, it's no surprise they concluded that one in itself was inadequate. That was their finding on that part. But the problem, of course, is they were misinstructed, and they should not have been asked to decide that narrow question. And indeed, we know they wanted to look further because common sense would drive you to look further as a juror. They wanted to look further. They asked a question of the court. Can we look beyond this? Essentially, are we limited to the bags in answering 3A? And the court, again, over Union Carbide's objection, said, yes, let me be clear. The court said, yes, only the bags. And so that the jury reached the conclusion Your Honor's describing, but only by being artificially isolated in what they could consider under the first of the two Kaufman prongs.
Well, the jury still had to find that the inadequacy was approximate cause. So presumably, if they thought that inadequate warning didn't do it, that somehow the heating presumption was overcome, then your client would not have been held liable.
But they had been told, right? I mean, if there's a separate, I know, and we've talked. This came up earlier, and I know the point was made that that's not before the court right now in terms of proximate cause. But we'd never get there. I mean, we have to know what the jury would have concluded in terms of, look, if they're able to consider all of these things that were provided by all these materials and targeting the employee, what would they have concluded in terms of the later elements? Well, that is what would remain to be seen on remand once you had a properly instructed jury on the warning. And let me just, I think I did cover briefly, but I would like to just briefly respond so there's no confusion. There was some discussion back and forth with petitioner's counsel regarding the proper standard. As one or more members of the court noted, the standard that's stated on the face of Kaufman is whether the supplier manufacturer took, quote, reasonable steps to ensure that its warning reaches employees. That is obviously the restatement standard. As I mentioned, on pages 16 and 17 of plaintiff's response brief to the amici, they make the point citing a handful of cases. Feldman, I believe, is the first. Maybe I think Freund is also cited. Those cases are, when they're talking about focusing on the product and something being different about strict liability, they are not doing anything to detract from the fact that the question is reasonable steps to reach the employee. They're talking about the fact that when it comes to strict liability, there's one factor that's different, and that is that the manufacturer or supplier is presumed to know the danger. And I know that's been somewhat qualified in subsequent case law, but presumed to know the danger as a general principle. That's the difference. It does not, those cases themselves proceed to say the same reasonable step standard applies under both. The restatement on its face applies to both. So I just wanted to make clear there was no confusion that somehow a different standard was in play with regard to the strict liability count. If the court has,
and that's consistent with not every state necessarily, but that's consistent in state law around the country, that the reasonableness standard applies in this setting.
That's my understanding, Your Honor, and it is the restatement rule as well. Yes.
Please go on to the second issue. Go ahead.
Thank you, Your Honor. So I'll touch upon the second issue with regard to medical causation. A few points to raise here. There were instructions given, obviously. I believe counsel quoted, or the court may have quoted some of the instruction that was given. It said things like efficient cause or cause that isn't remote or trivial. The reason those are inadequate, the reason that the Schultes standard exists and has been applied in courts, not just in the summary judgment standard, but in cases like Kulak, it has been expanded and applied in cases involving, judgment notwithstanding the verdict and so forth. Kurak, excuse me, I think I said Kulak, Kurak. The reason that exists is because, as I think was mentioned in the earlier colloquy, it has the effect not of setting levels, but of focusing jurors on relevant factors, namely frequency, regularity, and proximity, time, and physical location. And there were some questions asked about whether it's been properly applied in the context of mesothelioma. Well, clearly it has been applied in that context. For us, as we cite, Kurak is another, in addition to some unpublished decisions that we cite. But the reason for that is that it is a flexible standard. By not setting particular levels, as James recognizes, by not setting particular levels, the question of, okay, this is mesothelioma involving a particular type of asbestos, how much proximity, how much regularity and frequency is required is precisely, as the court noted, that's something for the experts to dispute. And indeed, in this case, while the science continues to develop, there are questions about where we are in the science. It was hotly disputed in this case whether the type of asbestos at issue here, for example, can even be linked to mesothelioma. So
tell me if I'm wrong about this. Schultes simply provides a framework. Schultes doesn't say that the worker has to have 5 years of daily exposure, or the worker has to be within 10 feet. It's setting a framework of what considerations you would apply. So if a plaintiff's expert, as Ms. Long indicated, I'm sure she had an excellent expert, comes in and says, on this particular type of mesothelioma, it can be caused by exposure, let's use the most extreme, to a single fiber on a single day. That's not inconsistent with Schultes, is it? It just merely provides, Schultes provides a framework under which a jury could then say, well, in this case, I liked her expert. I think her expert was the better expert. And that expert says it takes a minute for this.
That's precisely correct, Your Honor. And that is, James recognizes, I believe it's James that says, there's not a level set by this standard. Rather, it is a framework, precisely as Your Honor described it. It's a framework to focus jurors on something other than just hearing the phrase, for example, here, efficient cause.
So why isn't the language that the judge gave and that was cited by your adversary accomplish the same goal? Can't be casual, can't be minimal, can't be guesswork, and must be a substantial factor. Why doesn't that, there's more to the charge, but why isn't that conveying what the jury needs to know? And why isn't that basically just another substitute for Schultes?
Thank you, Your Honor. Well, I think Schultes itself recognizes, at least implicitly, in coming up with the standard. And so many courts have recognized and since applying it, including, Kurak, in trying to walk through and decide whether there was enough evidence. What's missing from that is it identifies sort of a general sense of requiring something, not nothing, but it doesn't identify what kinds of factors. It doesn't identify the temporal factor, that regularity and frequency. That's about time. So it doesn't identify distance. It doesn't say, okay, jurors, consider distance.
So let's take time, and you can help me out because I don't know the science here, but we've heard some statements that even a small amount of exposure to certain fibers will result in mesothelioma. And so long amount of time isn't necessarily going to do it. Small amount of time, small amount of exposure. Is that part of the science?
My understanding of the science, Your Honor, is that it is depending on the type of, and there are different types of asbestos and so forth, that depending on the type, my understanding is that the science remains contested, and that you may well have an expert say exactly the words Your Honor just said with regard to whatever asbestos type is at issue in a case. And under those circumstances, a properly instructed juror, you'd have the plaintiff's lawyer saying, you heard our expert. One is enough. So when it comes to frequency, the answer is one. When it comes to regularity, you don't need regularity. And when it comes to proximity, you heard our expert say anywhere in the same huge room is sufficient. And then you'd have the defense make their counterpoints based on what their expert has said. And the reason that this is a proper and flexible standard, the reason that it's proper standard is it's a flexible standard. And because it permits precisely, the jurors have to, we can't presume that one or the other expert is correct and then craft the instruction based on that. This permits the jurors to decide what they think is correct and to use this framework to channel their thinking. And that avoids the guesswork that Schultes itself says we have to avoid in this context.
Indeed, Schultes is really not skewed toward either party, is it? It's not a keep them away from the jury kind of standard. It is simply recognizing that unlike a workplace accident with a machine, unlike many consumer products that have somebody hurt with an orthopedic injury or something along those lines, these are exposures that may or may not take certain amounts of time. And in this case, listen to the experts, decide if you reject them or accept them.
Correct, Your Honor. And to your point, while we can't see what goes on in a jury room, we can read an opinion like Kurak and see that a court applying that standard in sort of the JNOV context post-verdict is, finds that some of the exposure, enough was shown under on the record in that case. Enough was shown to satisfy Schultes as to another exposure from a different manufacturer. Insufficient. The same standard absolutely can cut both ways. It depends on what the science record looks like in that case.
Or anything else you'd like to add to your argument?
Thank you, Your Honor. I'm looking just very briefly at my notes, if I may.
Go ahead. Go ahead. Take a minute.
Thank you. The only thing I would add, Your Honor, very, very quickly, there was some discussion of harmless error, and we would reiterate a point made in our briefs that under this court's decision in Washington and others, that the presumption is that when there is material error on the face of a jury instruction, that it is prejudicial, and that the standard is appropriately a low one. Could the jury have come to a different result? And we would respectfully argue that that is the case as to both errors in this instance.
Thank you very much. Ms. Long, a few succinct points in rebuttal?
Yes, I'll try to be very succinct, Your Honor. Starting with the issue that I'll work backwards and start with the issue that we just left off with the Schultes language and the medical causation instruction, and just make a couple of points in response to counsel and in response to the questions that Your Honors propounded during his presentation. I think that it's important to recognize that there's a difference between experts giving competing testimony about causation proofs and the court endorsing a certain standard when it instructs the jury. So for instance, counsel was saying, the court can instruct the jury that you need sufficient regularity, proximity, frequency, but then plaintiff's expert can come in and say regularity doesn't matter. That, if the science is regularity, it doesn't matter, as recognized, it may be contested by defendants experts, but as recognized by our courts in Curac and other cases, if the science is that regularity isn't a large factor in mesothelioma, then the instruction has to encompass that. It can't just say you have to prove sufficient regularity, frequency, and proximity, and then leave it to a plaintiff and their expert to say regularity doesn't matter. How does a jury understand, or how do they believe a plaintiff's expert that regularity doesn't matter with respect to mesothelioma if the court's telling them you have to find sufficient regularity? So I think that's isn't
that the way it's phrased? Couldn't it be phrased as you should consider these factors in determining whether the plaintiff has met their burden?
I think that would be an excellent question going forward in as amici counsel from the NJCJI suggested, in considering whether the model jury charge should be changed to include that language in toxic torts. But I don't think adding that or the exclusion of that language made the charge that the judge gave in this case error.
But just to sum up on that, Ms. Long, would you agree? And I understand you've got an issue in this case, an appellate division decision, sending it back for a new trial. But would you agree that a charge that neutrally guided the jury to consider those factors is not only consistent with Schultes and James, but would also potentially, depending on the case, may actually be helpful to a plaintiff as well as a defendant? There's nothing inherently unfair about Schultes.
Again, if it's modified by the Curac language and was done in advance by the committee so that it was part of our model jury charges, so that a trial judge had that guidance when she instructed the jury, I'm not philosophically opposed to including some sort of charge that would be fair, but the appellate division hasn't considered all those sides. There hasn't been that opportunity for a process where all interested parties can raise the scientific issues, can raise these issues, and we can have the type of process that the court endorses when it discusses the model jury instruction. Turning back to the first issue, it is not plaintiff petitioner's position that it is only the warnings on bags ever in every case. I just want to make clear that in this case, the facts were that Union Carbide's only communication with the product users, the only thing that was on or accompanied the product was the product labels on the bags. So that's why the focus, why the court let when the jury asked, why she let them know that in this case, it was only the bags that they should consider. So if the manufacturer has made other communications with the product user, if that were the facts of the case, the jury could consider that. And Your Honor raised the question of whether Union Carbide has the ability to go in and put up posters. Union Carbide always has the ability to not sell its asbestos to an employer that won't take the safety measures that it asks it to. So it does have some control. If it says, we will only sell you our asbestos if we can come in and make sure you hung up these posters or handed out these pamphlets, it does have that power as the seller of the product. It can make that choice.
This goes through a distribution network, does it not? Union Carbide doesn't, presumably they're industrial distributors. Union Carbide sells to distributors.
Primarily, they sold directly. There was a short period of time where there were a few distributors, but primarily all of their sales were direct to Mr. Edenfield's employers. And even if they had distributors, they could make agreements with them to make sure that communications directly to the product users were put in place. And so I just want to take away some of that dichotomy of it's only on the bags, that's the only thing they can ever do. There are ways to communicate with the employer or employee. And again, I want to address the safety point. Kaufman addresses this issue of warnings in the workplace. It came up with the dual duty to address all these issues of what's the best way to warn an employee and how do we get multiple sources of warnings in place. And it said you have to do both. It talked about a concurrent duty to warn both. And the rule that was adopted by the appellate division would allow the warnings to the employer to completely replace the warnings to employee. Indeed, you could have a case where there's, like this one, an patently inadequate warning on the product, and the manufacturer can escape liability based on what they told the employer. You could have a defective product with no warning on it, and they could avoid liability. And there is a difference, even though the bag goes through the employee, and this was discussed in the Whalen case, the point of injury, the point where the warning needs to appear is when the employee picks up that bag of asbestos, takes it out of the shrink wrap pallet, opens it up, pours it. That is an excellent opportunity to get that warning to the product user at the critical moment when they're being exposed to the asbestos. And as the court has recognized, there is no burden on, or an exceedingly minimal burden on a product manufacturer to put such a warning in place. Finally, just to address the council's characterization of Frund and O'Brien, those cases did not deal with the solely with the issue of whether we impute knowledge to a manufacturer or not. Frund was specifically about the issue of whether it was error for a jury in a failure to warn case to get only negligence instructions. And the court found that that was error because the jury could have found that a manufacturer who carefully produces its products is not liable even if the product was unsafe. And the court said that result is not okay under strict liability. And in O'Brien, it said that a manufacturer that produces defective products is liable even if those products are carefully produced. And in Frund, it said that if the warning is inadequate and the product is still safe, the manufacturer cannot be relieved simply because they were careful and reasonable, which is exactly what the appellate division has adopted here and what this court should reject, following our long-standing strict products liability failure to warn case law. Thank you.
Thank you, Ms. Long, and thank you to all counsel.